Welcome everyone to this morning's rulemaking, and we're going to ask Mr. Dong to read the docket.
Good morning. Mr. Chairman and other members of the Commission, this hearing is being held under docket number 2019-59A. It's a public hearing on the proposed regulation 103-817.1 on e-filing and e-service. In the filing of the proposed regulation with the General Assembly, members of the public were given an opportunity to submit written comments and to present oral comments at today's public hearing. Mr. Chairman, other commissioners, the docket is in order.
Thank you.
Mr. Chairman.
Mr. Whitfield.
Thank you, Mr. Chairman. This is kind of a rare opportunity. I understand it's been quite a while since we've done this, perhaps going back even before my time on the commission. At this point, I understand that in order for us to get an explanation from Ms. Boyd, we need a motion, and I so move that under Code Section 1-23111, that I would like to move the proposed reg that Attorney Dong has referenced for consideration. So at this time, I so move that we take up this proposed regulation.
Okay.
Mr. Chairman.
Yes, ma'am.
Pursuant to the Administrative Procedures Act, I move that we put into the record, as record of evidence of record, the notice of drafting, and the notice of the proposed regulation, which was, I believe, published in the State Register, and ask that those be marked as hearing exhibits.
Okay. So.
That's fine with me, as my understanding from Mr. Dong. That is all that is in there, but so if it's necessary to amend my motion, I certainly accept what Commissioner Belser said, but Mr. Dong, if I understood you right, that's there. Is that correct?
They need to be marked as exhibits.
Okay.
Okay, Mr. Chairman, if you could assign them a number, or
Well, there will be exhibits number 1 and 2. Okay. So we have a motion on the floor to, and we've marked them
already.
Okay. So we don't need any kind of vote.
Ms. Boyd can proceed.
Ms. Boyd, please proceed.
Good morning, Mr. Chairman and members of the Commission. I'm just going to do, if you don't mind, review the proposed regulation with you. We did submit to the Legislative Council for publication in the State Register 2 documents so far. The first one was the Notice of Drafting that was published in the State Register on February 22nd, 2019. And the second document is the proposed regulation, which noticed today's hearing, and it was published in the State Register on May 24th. So, Mr. Chairman, as you're already aware, the Commission has been maintaining and adding additional features to its docket management system since 2005. We already currently, our first process or upgrade to DMS included the ability for authorized electronic filers to e-file documents on our docket management system. And from there, the General Assembly actually later on amended our statutes so that we could electronically serve commission orders on the docket management system. After that, we asked for one of our regulations to be amended so that we no longer had to serve documents that contained hearing dates by certified mail. And we've saved, we published that information in our accountability report, you can see where the amount of money that we previously expended for certified mail for those type documents has consistently declined because we were granted permission to serve our notice of filings, our notice of hearings, pre-filed testimony, and transmittal letters through DMS. So as you can see, we progressively enhanced the features and the transparency of the Commission's operations regarding its filings in DMS. This is one of our next steps, this proposed regulation that's before you today. I know that as we move through this process, there will probably be other enhancements that we will want to make to DMS because technology is always changing, and we want to make the practicing over here before the Commission effective, efficient for those stakeholders who have an interest in our proceedings. So this last, what's before you today, is to ask permission to add a regulation that provides a process for the Commission to electronically serve documents that are electronically filed with the Commission. And the regulation will provide a documented procedure for parties who utilize the docket management system's electronic filing or e-file system. So now I'm going to move on, Mr. Chairman, to the actual regulation. We are proposing to add a new regulation, 103-817.1, and the notice of drafting that was published back in February notified interested persons that the Commission was going to closely mirror or follow the South Carolina Supreme Court's electronic filing policies and guidelines, specifically guideline 4 regarding e-filing and e-service as we created this regulation. So these slides are just highlights of the, that I'm presenting to you, highlights of the regulation. So electronic filing. Electronic filing is the electronic transmission to the e-filing system, and once that transmission takes place, it constitutes the filing of that document. E-filed documents will be considered the official record. What are the timeliness of filing an e-filed document? A document transmitted and received by the e-filing system on or before basically midnight Eastern Standard Time shall be considered filed with the Commission on that date, provided it is subsequently accepted by the Commission. We wanted to stress that because there might be a defect or whatever. So it needs to be, the e-filed document needs to be accepted by the Commission in order for the next steps to take effect. This notice of electronic filing, we've been talking about this with a couple of other entities for a while, and I have a couple of examples from two different bodies, Mr. Chairman, because we've been working on this issue for quite some time. And I can show you some examples of those notice of electronic filings. Basically, the notice of electronic filing will be generated after the clerk's office employees review the filing and say, okay, this document should be accepted. Thereafter, this notice of electronic filing will be generated. It's generated by the e-filing system at the time of a filing or other Commission action. It's transmitted by email to all authorized e-filers who have filed a notice of appearance and are counsel of record. And it includes a description of the filing and a list of the parties to whom the NEF was transmitted. Now, as I said, we have examples that we've gotten from other entities such as U.S. District Court. They've had NEFs for a while. But with our advisory group, we will be able to work with them once this regulation hopefully passes the General Assemblies, it receives its approval, to determine if there's any other additional information that our stakeholders would like to see in the NEF. Okay, what's significant about this regulation is, and this rule is also in the guideline from the Supreme Court, electronic service is not authorized for any pleadings initiating a case. Excuse me, so our summons and complaint, the rules to show cause that ORS files, we'd still use the traditional means of serving those persons through certified mail, through their agent for service of process. So if it's an application, if it's initiating a case, we will not use the notice of electronic filing to process that. The documents that are accepted after that this regulation would apply to those. So this slide just includes the steps. What happens? The e-filer utilizes the DMS e-filing system to file a document. The document is thereafter accepted for processing by the commission. The e-filing system will generate a notice of electronic filing to all authorized e-filers associated with the case. And then upon the e-filer's receipt of a confirmation email stating that the filing has been accepted for processing by the commission, the e-filing of that pleading or any other document, together with the transmission of the notice of electronic filing, constitutes proper service. So hopefully we're helping our filers get on with the next task they need to worry about. If it's a motion, they electronically file the motion with us, and then we take care of the service. And then that service then also that service of the NEF will be available for everyone to see on our docket management system, just like you can see with our orders when someone accepts service. The regulation also includes language about service being complete upon e-filing. The act of an e-filing the pleading, motion, or other paper is the equivalent of depositing it in the United States mail under Rule 5B1 of the South Carolina Rules of Civil Procedure, Title 58 of the South Carolina Code, and Chapter 103 of our regulations. The NEF constitutes proof of service, and date of service shall be the date stated in the NEF as the official file stamp. And the e-filer needs to also retain a copy of the notice of electronic filing in its files as proof of service. How long does someone have to file a response after receiving a notice of electronic filing? Well, that will be governed by our existing statutes and rules. And petition for reconsideration, those rules would still apply for responses. Motion, our regulation rules would still apply. Okay, so what about someone who's not an authorized e-filer in a case? How are those cases handled? And the Supreme Court's rules already address some of this. We tried to model our regulation as closely as we could. But a traditional filer would be someone who is not an authorized e-filer. They don't have an account. Sometimes the commission has allowed someone who's not an attorney for a particular docket to become an e-filer for that docket if they were going to be active in the case, and therefore they too might not be considered a traditional filer even though they aren't in South Carolina, a lawyer who's licensed to practice in South Carolina. So if there is a traditional e-filer who is not an authorized e-filer, they have to be served by the traditional means. Either leave it with their attorney or mail it to them, and then we would still need a certificate of service from that transaction. Traditional service in the regulation is governed by Rule 5 of the South Carolina Rules of Civil Procedure. So they would follow that rule. They would also follow our Title 58 if there are some other applicable rules in our statute or in our regulations. So that's what would govern service of someone who's not an authorized e-filer. And finally, what if an authorized e-filer learns that the notice of electronic filing is deficient or not properly served? So if the notice of electronic filing is not transmitted successfully to other authorized e-filers, or the notice of electronic filing is deficient, the authorized e-filer shall serve the e-filed document by email, hand delivery, facsimile, or first-class mail. And thereafter, proof of service for the failed transmission shall be e-filed with the commission within 1 business day of service. Okay, Mr. Chairman, I'm available for questions. I think you also, I don't know if Mr. Dong has informed you, 2 persons who may or may not want to speak to you about this regulation.
I kind of noticed them over there.
Did you?
Yeah, first, before, I need to acknowledge that Commissioner Williams is joining us by phone, so that he is here in the meeting in an official capacity. Any comments?
Thank you, Mr. Chairman.
You're welcome, sir.
I had a quick question for Ms. Boyd. I think I understand her presentation, but I just want to make sure that I'm clear, if I may, Mr. Chairman.
Certainly.
Ms. Boyd,
Yes, sir.
thank you for the presentation. The last part you discussed about parties that are not approved or official e-filers. It seems as if the new regulation provides avenue for what I would call traditional filing.
That's correct, yes, sir.
Okay, and so our e-filing, this new regulation does not make it mandatory, but just option available. Is that the way I
Well,
understand that?
if, for example, Vice Chairman Williams, if I am an attorney in a case and I'm representing Y utility, and you're representing another entity, but you are a party in the case. But I'm an authorized e-filer. I have an account with our docket management system, but you don't. Let's say you're not representing anyone. Let's say you're pro se. So I'm an authorized e-filer. I've been through the process and I've submitted electronically my application. I have an account. You, however, as a party in the docket, are not an authorized e-filer. So you would be considered a traditional filer because I can't serve you technically, officially, because you're not an authorized e-filer. Do you understand where I'm going so far? Just so far?
Right, I got
Okay.
you. I got
All
you.
right,
And
so-
I'm thinking about that pro se litigant, our good friend Mr. Nobody, if you will.
Yes, sir. If he's a party of, if he's a party of record in the case, Mr. Vice Chairman, he can ask the commission, if he's going to be active in the case, he can ask the commission for that particular docket to authorize him as an e-filer. So he would be able to receive those documents electronically if he or she so chooses. You said Mr., so he. Okay? But if Mr. somebody says, I don't want to, I want to receive the documents the traditional way, then Mr. somebody would have to be served through U.S. mail or email instead of through our notice of electronic filing service.
I got it. Thank you so much.
Yes, sir.
Thank you. Thank you. Mr. Nelson,
Yes, sir.
you can stay
Ms.
seated
Boyd, I
right
just-
down there if you want
thank
to.
you. If I can
That'll
squeeze
easier
this
to
thing far enough.
get to the microphone.
I just wanted to clarify a couple things and just make sure so, Ms. Boyd, under this now, there's no opt-in or opt-out. If you are registered as an authorized e-filer, you are automatically going to get served.
Yes, if this regulation passes the General Assembly, yes, sir, you will be automatically served.
So there's no longer the need for an agreement of the parties to be served electronically.
That's right. There was a regulation that passed years ago that said, okay, if you're parties in the case, there has to be this written agreement for you to serve each other electronically. This regulation would get rid of that process.
Now, assuming I'm in a case, how do I know whether or not the attorney or the other party is an authorized e-filer? Will something appear as far as under that docket on the DMS or something? Or, in other words, how do I know when I need to serve somebody by mail? Because
Someone
I'm
who is
an
not.
authorized e-filer?
I think we've attempted to include that now on DMS, where someone I think it's the representative page. If you indulge me just a little bit, Mr. Nelson, we're probably going to have to enhance that feature. Let's just go, and I think it's on the representative page where it states this party has agreed or not agreed to receive service. Give me 1 second. Okay, so representatives. So see this right, okay, I'm under docket number 2019-184-E. And you see over here where it says agreed to service, I'm sure we're gonna have to modify DMS, but we've kind of started that process a little bit. And I think once this regulation passes, there will need to be more detail as to why. I hadn't been able to envision that yet, but I think we have the ability so that you will know whether or not they are an authorized e-filer or they aren't. Okay?
Thank you, Ms. Boyd. Appreciate it.
Thank you. Any other comment?
Mr. Chairman.
Hang on 1 second. I was going to Mr.
Mr. Hall.
Torini next, and then Commissioner Belzer, then I'll get to you.
Didn't mean to step on your comments, Commissioner Whitfield, if you, but I could not pass up the opportunity to be here for this. This is just, this regulation is a tremendous improvement. And the commission staff is to be commended for working so hard to get this done. I know it's not a simple thing. It requires technological improvements and a lot of work on the DMS side of things, as well as getting a regulation through the General Assembly is not the most fun task in the world. But this will bring the commission in conformity with the existing practice in both our state and federal courts. And as somebody who has used both of those systems, it is just a tremendous improvement over what we have now. Not that what we have now signals any shortcoming of the commission, because I'll point out that when the original regulation that was promulgated, the one that allowed agreement for service by email, this commission was ahead of the circuit courts and was saying, well, if you can do this and if you can serve people by email in federal court, why can't we serve people by email at the Public Service Commission? So this just continues the commission's longtime commitment to make practicing here easy, efficient, and transparent. And DMS is all of those things. And I urge you, if you haven't had an opportunity to do so, to compare it to websites used by FERC, the FCC, and I won't name names, but perhaps commissions to the north of us, and see just how much better DMS is. And frankly, it's better than PACER and the state system in terms of public transparency. It's just very easy to use, and members of the public can access it. Those pro se filers, in my experience, more often than not, want the electronic service. I was recounting one incident in which a pro se litigant complained that why were we stuffing his mailbox with all these pleadings? Well, it's because they were required and he hadn't signed the agreement. So this just brings everybody into the 21st century, and I want to thank you.
Thank you. Commissioner Belzer.
Thank you, Mr. Chairman. Ms. Boyd, thank you for your presentation. If we have if the commission has a traditional filer in a docket, and they are filing by mail or receiving a commission order by mail, will they receive the extra 5 days allowed under the Rules of Civil Procedure for service by mail to respond? Does that add time, and are we gonna have e-filers due on one day and traditional filers responses due another date?
I don't think that that's our current rule.
Well, but when this
I'm trying to think, Commissioner. I don't think that's our current rule.
but we are referencing under 5D. Does that bring into effect the other? Might just be something we need to be aware of.
You said 5D?
In the proposed regulation under traditional filers, it is well, I reckon that's the proof of service, but or look under 5A. Traditional filer must be served by a traditional service method in accordance with Rule 5, Sectional Rules of Civil Procedure, Title 58, and Chapter 3. And when we add in, I reckon my concern is, and I don't have the Rules of Civil Procedure
I have them if you
with
want to look
me,
at this.
is the extra 5 days for service by mail. I actually think it's a separate rule, but it does reference 5, or it is pursuant to 5D, is it not? It's just something to consider that we're going to have.
I guess I'm trying to follow where you are.
I'm under, if you look at the last page of the proposed
Right.
regulation,
Mm-hmm.
under Section 5A, and line 3 says it must be served by a traditional service method in accordance with Rule 5, South Carolina Rules of Civil Procedure.
Right, yes, ma'am.
It may not be applicable, it just, I think we had this discussion back with the
Oh.
advisory committee when this rule was discussed.
Okay, are you I'm looking at 5, and I'll hand this over to you. Are you referring to Rule 5, South Carolina Rules of Civil Procedure? And the D says all papers required to be served upon a party, except as provided in Rule 26G1, shall be filed with the court within 5 days after service thereof?
No, I'm talking about when certain service is served by mail. It adds 5 days to the time, well, except in an appeal, it doesn't add it. But
Oh, I see what you're talking about, I think.
when service by mail is affected by mail.
Okay, you're talking about Rule 6, so that would actually fall under, I think, instead, time
Computation of time.
Time computation, that's correct.
All
So
right.
you're talking about Rule 6, which is time, and it's section, 6, is section 6E, additional time after service by mail or upon statutory agent. Whenever a party has the right or is required to do some act or take some proceedings within a prescribed period after the service of a notice or other paper upon him, and after the notice or paper is served upon him by mail or upon a person designated by statute to accept service, 5 days shall be added to the prescribed period. I think that's what you're referring to.
Yes.
So that's Rule 6,
Okay.
and that's Section E.
All right.
Okay, so that's under
That's not going to
time.
be applicable.
Well, and here's the thing, you're right. I mean, proposed regulation says time to respond following electronic service under the proposed regulation.
Okay.
See that? So that's another issue I think that you're referring to. So what happens when these non-traditional filers receive a motion, for example? And I would think if we're going to operate under that, we'd be operating under that right now, though, right? Yeah, under that rule right now. And I don't know, I hadn't seen that yet, where that issue has arisen, Commissioner.
It was just a thought that popped, that went during the presentation, because I actually agree with the comments of Mr. Torini. I think experience has shown that even pro se interveners and some of the pro se applicants have preferred to be contacted by email. However, there have been some that have refused to sign on to the agreement to allow for service by everyone.
Yes, ma'am.
And it just came under. I think I agree that this is, I think, a good step forward and will aid in, I think it'll aid the parties greatly. They will receive, they will continue to receive filings quickly and not have to worry about doing anything by mail.
Yes, ma'am.
Most of our attendees, and it does provide for those that either choose not to use email or may not have access to email, it does provide an avenue for those persons to participate as well. So I commend you and the commission staff, as well as the advisory committee that commented on this when y'all were in the early stages. We're coming up with this rule. Thanks very much.
Thank you. Commissioner Whitfield.
Thank you, Mr. Chairman. I think most of my questions have been asked. Just wanted to certainly go where Commissioner Belser did and commend Mr. Torini. Certainly his comments were appreciated and heard and recognized. I want to go back to Mr. Nelson's question, Ms. Boyd, where he talked about the filer having to know whether or not that any or a party or any party in a matter is an e-filer, and if not, I think you somewhat addressed his question, but I'm going to turn the question just slightly. What if that pro se or that person, well, let's just say, let's say it is unknown, but that person requests traditional filing. Is that person, I guess what I'm saying is it incumbent upon the attorneys filing to know the status of all the other parties in the proceeding, or should they wait for that one individual, and I say pro se, I'm assuming it'd be a pro se litigant, to raise their hand and say, hey, I'm not e-filer, I want to be served traditionally?
Well, I think, Mr. Commissioner Whitfield, that we will have to find probably, more than likely, on this screen that I'm showing you right now under the Representatives tab, I envision that the third column, which says agree to service, I think that's going to need to be modified. If they are not an authorized e-filer, I envision that column perhaps changing the title of it to state authorized e-filer, yes or no. I think it perhaps can be that simple, but that's just what I see right now. Others in the advisory group might say, no, I think it needs to say this, or maybe you need to have two columns there instead of one. But if that column, I think, reads perhaps authorized e-filer, our system will automatically know whether or not they are, and if they aren't, we can designate them as such. And as I said, you know, we've had in the past, I can think of at least one person who was pro se, and they asked the commission to be able to e-file, even though they're not a lawyer, but they were active in that docket, and so their the response for them being an unauthorized e-filer for that docket would be yes. So I think perhaps that's one way we could handle this concern about who's an authorized e-filer and who's not.
Right, right.
Sense?
Yes, ma'am. And I guess just to kind of sum up back to what Mr. Torini said, we certainly, and he certainly pointed out how we're bringing ourselves into the future, if you will, or to the current procedures of federal and state courts, and we certainly want to be on the cutting edge, as he alluded to. We've been ahead of others in the past, and we certainly want to stay with the times. But at the same token, we serve the public here, and as you've often stated, Ms. Boyd, our mission here is to not only be transparent, but to be inclusive of everyone. And I'm just trying to make sure there's a member of the public or pro se who is not left out, if you will.
Well, and to ensure that, what I will tell Mr. Erskine is when we start these stakeholder meetings, that we include at least one or two people that automatically come to my mind right now that I think would be more than willing to give us their feedback about how we're going to transform DMS once this regulation is blessed by the General Assembly.
Thank you.
Thank you. Any other comments from anybody? Okay, I just want to say thank you to Ms. Boyd and staff for.
Yeah, you've got a great.
This has been a lot of work.
Yes, sir. And Mr. Chairman, if you allow me to say, you're not only the other staff that have really helped and taken field trips with me to the court administration. They've been so kind to us. The U.S. District Court's clerk's office. Anytime we need anything and we want to know about their model, they open their doors and are just so helpful. So we've had a lot of help, and as Mr. Torini said, this has been on our radar now for several years. So yes, sir. Thank you.
Great, Mr. Dong.
If there are no further comments, I'd like to thank you for your attendance today. Pursuant to Code Section 123-111, the record will be kept open until the close of business on Wednesday, August 28th, 2019, to receive any additional written comments that anyone would like to submit, and at that time, the record will be closed. That's all I have.
Thanks. If there's nothing else, then we are adjourned.